to serve. Mr. Federico, let's start with you. During the Trump administration, during the early weeks of the Trump administration, there was an announcement made about some changing procedures for handling expedited removal proceedings. You made a rather lengthy blog post on the Federal Public Defender blog. I was a little surprised to see that because as a federal public defender, this is pretty clearly outside of your domain of where you operate as a federal public defender. In fact, in the post itself, you acknowledged the distinction between criminal proceedings, including criminal proceedings, for example, for illegal reentry, which is a federal offense, and removal proceedings, which are civil proceedings, not criminal proceedings. In which you're giving, in this post, you're giving advice, as far as I can tell, to individuals who may become subject to expedited removal proceedings. And the post lists these practical tips for people who find themselves in that circumstance, telling them what to do, what to say, what not to say, what to do in advance, how to arrange things with their documentation, arrangements for their children, and so forth. And then you attach a separate document that gives additional advice, a document put out by the ACLU. Now, it is understandable why the ACLU might put out a document like that, but I was surprised to see you put this out on the website, on the blog attached to the official website of the Federal Public Defender's Office. Just tell me why did you decide to write and publish this, and how is this consistent with your role as a federal public defender?
Senator, as I recall, I was asked to write that blog post by my office leadership, I think because we were getting a lot of calls about immigration matters. If I recall that blog post, also there is another lawyer who is an immigration lawyer whose name is on it as well. And I think we were careful to say, even though we do, as you noted, handle a lot of immigration matters in the criminal context, we were simply not taking any position on the policy changes, or if there were changes, simply stating what legal rights persons may have, which is sometimes what lawyers do.
Now, you are listed as the author of it. There's, in small text, very faint, some mention of a Melody Brannon. Is this another lawyer?
Yes, sir. Melody Brannon is the federal public defender for the District of Kansas.
Okay, and does she have a role in removal proceedings?
No, sir.
Okay, so it's also interesting that at the bottom of the post, you note, quote, that the document is not, quote, not meant to be and should not be relied upon as legal advice regarding immigration matters, close quote. So as best I can tell, this is more of just sort of a political statement. Does the Public Defender's Office in Kansas often make political statements or comment on political issues that are outside of its jurisdiction?
Senator, I'll speak for myself only, and I certainly don't or don't intend to.
And as someone who's employed by the federal government and an officer of the court, is it appropriate to issue documents that could be interpreted as facilitating the breaking of the law?
Well, Senator, certainly breaking of the law as a lawyer, I can never counsel clients to do that.
Okay, and how is this differentiated from that? So you're not, so that one of the things that I found interesting, when I discovered this, I went and found the blog. So I wanted to see what the website looks like as a whole and what the blog looks like as a whole. I couldn't tell right at first whether this was something operated independently by lawyers freelancing who happen to be employed there. It's not. This is attached to the official document. So this was published at government expense, operated on a government server. The rest of what I saw on there, obviously there's a lot of material there, but from my scanning through it, through material posted over years, the rest of it made perfect sense. As one who has long practiced in front of the 10th Circuit, it made sense to me. Here are the sitting dates for the 10th Circuit. Here are the hot issues affecting criminal matters before the 10th Circuit. Here are some issues related to motions to suppress based on this or that kind of evidence gathered in response to a search warrant, or things like that. This one was an aberration. It goes completely outside of your work on behalf of any clients and can be interpreted as advice to ameliorate the effects or perhaps even to facilitate the breaking of the law. How can we be certain that if we confirm you as a judge, you will be an even-handed arbiter of the law and not someone counseling or encouraging or facilitating someone in breaking the law?
Senator, I will do my absolute best, as it is my professional duty to be a neutral arbiter of the law, as I've done as a military judge. In regards to that blog post, again, all of our clients charged with criminal immigration offenses have corollary administrative immigration matters. So they're relevant to each other because it's the same client. As I recall, at that time, we were getting a lot of inquiries again about immigration matters. It certainly, and I believe there's another name that was immigration lawyer who was cited in that blog post as well. Our intention was merely to explain some of the differences between a criminal matter and an administrative immigration proceeding, and to state some of the rights people may have, which again is what lawyers often do, whether you work at a law firm, the federal public defender, or elsewhere, just stating legal rights.
Yeah. Thank you.
Senator Blumenthal.